Hey everyone, welcome back to the Irretrievable Breakdown podcast where we discuss all things divorce. I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and I am joined by my co-host and the managing partner of our firm, Nicole Bikakis. And today we are going to talk about what should be in a parenting plan if you are going through a divorce or custody case here in Connecticut. Nicole, why don't you fill me in on how your weekend was?
Let's see, we had family in town, so we had guests staying with us. My brother-in-law and his girlfriend came up, and my some aunts and an uncle that lived down in Charleston came up and stayed with us. So we had a good weekend. We went into New York City for our niece's baptism.
Nice. And you were just telling me that your brother-in-law came to town and there was a big round of golf at the new Yale golf course here in Connecticut. Was recently restored. So your husband, who played again? Your husband
and my brother-in-law.
Gosh.
Both two brother-in-laws. My sister's husband and then my husband's brother.
Right.
And then my husband's brother's girlfriend. They all played. That was the foursome.
Gotcha. And your 5-year-old son Tommy, you were sharing, was devastated that he was not invited to play golf.
He discovered that they were golfing without him, and the tears were extremely real. And I felt heartbroken for him. He was really at a loss.
That's awesome. Tommy tried to work his way into one of my golf rounds like a week ago when I invited Connor. Connor couldn't play, and Tommy asked if he could play instead, which, if I were a better person, I would have just brought him. But I'm not that good.
It's okay.
One day, soon I will bring him.
It's a good lesson for kids to learn. There are some things that are for adults and kids can't always participate in.
Well, golf is for kids too. It's just tough. Like
not every golf game, though.
Yeah. And it's like if you're adults trying to play golf and you're playing with a 5-year-old, it kind of changes the dynamic a little bit.
Mm-hmm. How's your weekend?
Good. I have moved back home. I had a new daughter 3.5 weeks ago, and we were staying with my in-laws for the extra helping hands. And now I have moved home like an adult, and we are having to parent by ourselves. But it's going well so far. You may hear my daughter in the background. My wife Jess decided to give her a bath in the room next door, like right when we started recording this podcast. So hopefully we don't hear her screaming. I don't think I can sort of hear her in the background, and she seems like she's doing okay with her bath. So we'll see. And hopefully I don't get in trouble after this recording for calling out Jess, because she probably heard me say that. So
you'll have to live with those consequences.
So we'll see. So as I mentioned before, we are talking about what should be in a parenting plan when you are either, entering into a divorce agreement, essentially, or a custody agreement. So a parenting plan, what it is, it's a document that is usually by agreement. I suppose if you have a trial, a judge can also, order a parenting plan. Usually a judge's orders are going to be more sort of brief, unless tailored to a particular situation. So we'll talk about what you should put in your parenting plan if you're doing it by agreement. And
although I will say a judge's order will address a lot of the things that go into a parenting plan. It'll just be the court ordering it versus you and your co-parent deciding on exactly what you wanted to say.
Correct. And generally speaking, like a court's parenting plan is like more sort of brief and to the point, I think.
Yeah, it's going to hit on the things that need to get hit on, but it's not going to go into a lot of detail, and it's not going to be super tailored.
Right, exactly. So the parenting plan essentially like sets the expectations for what the parents will do, both with regard to legal custody and physical custody. So legal custody is, who makes decisions for the child as to where they'll go to school, what doctors they'll see, etc. And physical custody is just the schedule and, where they are which parent they're with during certain times. So the main part of the parenting plan is just what is the regular week to week parenting schedule. And that can be a number of different things. There's sort of the traditional situation of the child living primarily with one parent. So it would say, the child shall live primarily with mom, for example. And the father will have parenting time, something like every other weekend from Friday to Sunday or Saturday to Sunday, and then maybe one or two dinner visits per week, or maybe one overnight, like every Wednesday in overnight, things like that. So that's the sort of traditional primary parenting time with one parent situation. There's also 50-50 parenting schedules are becoming more common. And the most common shared parenting plans are the 223 and the 2255. So the 223 is where the child will kind of go 2 nights with one parent, 2 nights with the other, and 3 nights with the back to the first parent. So what it looks like is Monday and Tuesday with parent one, Wednesday and Thursday night with parent two, Friday, Saturday, Sunday night back with parent one, and then parent two would have Monday and Tuesday night. Parent one would then have Wednesday and Thursday night, and back and forth. So it essentially is, again, 2-2-3, 2-2-3, 2-2-3.
And some
The
parents find that really difficult because it really depends on your kid and what makes sense for your family. But some parents don't like the switching of the days versus having dedicated days.
Right. So the dedicated days is the 2-2-5-5, and that is where the child or children will spend every Monday and Tuesday night with one parent, then every Wednesday and Thursday night with the other parent, and then you rotate the weekends. So what that ends up being is 2 nights with one parent, 2 nights with the other parent, 5 nights with the first parent, and then another 5 nights with the second parent. So that's just like easier to plan long term, because in the first scenario of the 2-2-3, on any given week, the parent could have the first half of the week or the second half of the week, depending on which week it is. Where on the 2-2-5-5, you always know that parent one is going to have the first half of the week and parent two is going to have the second. I personally like the 2-2-5-5. I think it's just a lot easier to plan things long term when you know that you always have Monday and Tuesday. And it can, it's better for the kids as far as like predictability, because they always know they're with one parent for the first half of the week. I think the 2-2-3, where it switches back and forth, is better for like really young kids, because they're won't be a longer gap of 5 days where they will only see one parent. So that schedule generally works with younger kids. And
Each
then,
schedule has its own pros and cons, and
right.
like you said, if you have really young children, under 5 or 4 years old, going 5 whole days without seeing your child or the child seeing the other parent may be too long. And so it doesn't really make sense to do the 2-2-5, but rather do a 2-2-3. But then for older children, that's less of an issue. And I've actually also encountered a lot of parents who enjoy doing a week on, week off schedule, because it's less transitioning for older children, meaning, less homework being left behind at one parent's house, or extracurricular uniforms and things like that. It could just be a lot to have to juggle
Yeah.
out
I
of
think
that.
that week on, week off schedule is pretty rare, though. Like,
I
again,
see it a lot. I see a lot of parents who prefer it and it works for their kids. Because
yeah.
when they're older, you're seeing your parents likely for a dinner, at your extracurricular games or practices, or because those things regardless of whose day it is to have the kids stay up with them, both parents are always permitted and welcome at extracurricular activities, practices, games, and things like that. And it comes down to where are they spending the night. I mean, that's
Right.
truly what the
Right.
physical custody schedule for older children is adjusting for.
Yeah, but I think if you're having like a trial and there's not an agreement, very rarely will you see will you see a judge ordering like a week on, week off schedule because again, it can be a long gap of time where you're not seeing one parent. If you go a whole week without seeing your parent, granted, to Nicole's point, there are extracurricular activities. So that week on, week off schedule, I think is more common when it's by agreement. Um, and then sometimes you just have to have sort of a more customizable schedule if, a parent has like a unpredictable work schedule, like a lot of police officers, for example, their schedules are just all over the place. Unpredictable from week to week, or maybe they're on a certain schedule for like 12 weeks. And then the 12 weeks after that, it's a totally different schedule. So what we talked about before is sort of the general framework, but there often does have to be more flexibility when parents have more unique work schedules. And again, you also don't have to follow any of these frameworks. Parents, if it's by agreement, you can sort of do whatever schedule works for your family.
Some parents will just, again, to Matt's point, where their work schedule is ever changing, so they can't really commit to specific days. They'll say something to the effect of each parent will get X days in the month or in the week with the child, and then those days will just change depending on the parents' schedules. And of course, that is something that can be accomplished where parents are able to communicate well and adapt to these different circumstances, and work together to make sure the kid isn't completely confused. So that where the kid is not feeling like they're constantly being pulled in one direction, or that they're feeling like they don't know where they're going to be on a given day or a given night. I mean, it really does require really good communication between the parents and a commitment to supporting the child through that sort of constantly adjusting schedule.
Right. Right. All right. So that's kind of the regular week to week parenting schedule. You then have to deal with holidays. So holidays, you can either alternate them, year on, year off. You'll often say like, parent one has, certain holidays on odd years and the other parent has them on even years. Or maybe you give one parent a certain holiday every single year if the other parent doesn't care about that holiday. So you can sort of do that however you want. So you should be thinking about like the major holidays. Let's see, we've got like in a calendar year, usually it starts with there's Memorial Day, Labor Day, 4th of July, Easter, um, Thanksgiving, Christmas. Those are sort of the big ones that stick out. If you're Jewish, then there's the Jewish holidays. You also don't want to forget like Halloween. Often parents care quite a bit about Halloween or Mother's Day and Father's Day. Usually you'll say that, mother will get all day on Mother's Day or maybe even Saturday overnight into all day Sunday. And same with fathers on Father's Day. You also might want to put birthdays into the parenting plan as far as, maybe both parents will see the child on their child's birthday, or if it's the parent's birthday, maybe they get the opportunity to spend that day with the kids. So you may want to put birthdays in. You don't have to. You also don't have to do like Mother's and Father's Day if you don't want to. And then separate from holidays, you have to deal with vacations as well. So there might be like a February vacation from school, an April vacation, or a winter break from school. And usually you'll see parents alternate each one of those vacations so that one parent gets Christmas break from on odd years and the other on even years. Or maybe you'll split the Christmas break and then April break and February break. If those are the breaks that your kids have, you'll usually alternate those. And then as far as summer vacation, what you'll often see is that each parent will have something like 2 non-consecutive weeks of vacation each and every summer, or you can allow it to be consecutive if historically you may go on like 2-week vacations during the summer, for example. And to deal with conflicting dates, if both parents want a certain week during the summer, what you'll usually do is say, okay, each parent gets 2 non-consecutive weeks on vacation. They will exchange their proposed dates by April 1st of each year or May 1st of each year. And if they have conflicting dates during the summer, then one parent gets final say as to the dates they want in even years, and the other parent gets final say as to the dates they want in odd years. So that's generally how holidays and vacations work. And then those days, holidays and vacations, they will supersede the regular weekly parenting plan. So if it's a holiday or vacation and there's a order about what is to happen with regard to parenting, the weekly parenting schedule is ignored on those holidays and vacations.
I mean, really, the parenting plan is just the framework for what the schedule is going to be for the whole year. And you have this presumptive schedule, which is where we were discussing before, where the kid is going to be on any given week. If it's one parent has primary physical custody, that means the child is going to be primarily with that parent, other than on the days where the other parent gets their stated parenting time. And then you need to make arrangements for the days of the year where the normal calendar, school calendar is not in effect. And so that's what you were just describing. It's like thinking of the holidays that your family observes, the holidays that, the country observes, so that there isn't going to be school. It's going to be a federal holiday. Schools are going to be closed, and the child's going to have to be with a parent on those given days, or one of the parents going to have to be responsible for the kid on those days. And then the breaks from school, and those are the breaks you described, and summer vacation. So it's really just setting an expectation as to how all of those days where the presumptive parenting schedule doesn't apply are going to be dealt with. And parents really vary as to how much detail they want to include into their parenting plans for these other days, the holidays and the school breaks. Because some parents, they feel like they're going to work it out. They don't need it put into a parenting plan. And other parents want it very detailed, very specific, so that there's no confusion and everyone's looking at their calendars a year out and knowing exactly what days are going to be theirs and what days are going to be their co-parents.
Right. And just as an aside, like if you have a parenting plan, you and your spouse or former spouse, you can always agree to deviate from the parenting plan by mutual agreement. So don't feel like just because it's a court order, you have to follow what's in the court order. If you don't have an agreement to change it, then you do have to follow the court order. But if the two of you decide, dad's supposed to have Christmas on an odd year and it's an odd year and mom, you agree that mom should have it on that year, you can do that. So don't feel like, we have to follow the court order because we might get in trouble if we don't. That's not the case. You can always mutually agree.
I mean, it's a backdrop, and it's really meant to be the default unless you guys agree otherwise. And if you guys are in agreement, great. You guys can adjust the schedule according to what you guys want to do with your kid. But if you're not in agreement, it acts as the default and the backdrop and therefore you guys can make plans. I mean, that's the biggest thing. It's why you really need a schedule, because you're going to need to make your own plans. And you need to know reliably when is your co-parent responsible for your kid versus when you have to be responsible for your kid.
Right. So another thing you may want to include in your parenting plan is transportation. So who is responsible for dropping off the child or children, and who is responsible for picking them up? You may, if it's primary with one parent, often you'll see the non-primary parent is sort of responsible for all transportation for them to begin and end their parenting time. And sometimes you will see it so that the parent who is beginning their parenting time is picking up the child, or the parent who is ending their parenting time is always dropping off the child. So you may want to include transportation in your parenting plan. Again, you don't have to. If you feel like the two of you can work it out, you don't need to include that.
And once kids are in school or they're in daycare, a lot of times that transition is happening from daycare or from the school. And so it's typically pick up from school or from daycare. And it's whoever is on that day, they're the ones that are going to be doing the pickup or arranging for the child to be brought home.
You also may want to include a provision for the right of first refusal. So, what the right of first refusal means is that, okay, let's say dad has parenting time and he's supposed to have, Wednesday, or for example, but he has to work or he has some event where he is not even going to be available to be with the child. And he instead has his new wife with the child or an in law or something. The right of first refusal basically says if either parent cannot be with the child for a certain period of time, call it 5 hours or 3 hours, they have to give the other parent the option to be with the child during that time period during which the parent who is supposed to have parenting time is not available. So sometimes you will see that in agreements or court orders. Again, you need to be very careful about the time threshold. You know, it might be 3, 5 hours, something significant. It can't be like an hour because that prevents, you.
Even 3 hours
Yeah.
is way too short.
Yeah.
Someone is allowed to when it's their turn to be responsible for the child, they're able to make some plans and then arrange for some kind of childcare, or if it's going to be one of their parents or a new spouse to fill in for them while they attend to whatever it is they need to attend to or be wherever they need to be without having to involve the other parent or force the kid out of their home. Because again, even those relationships are something the parent gets to uh, cultivate on their time, right? Like being able to spend time with the uh, grandparents and have the grandparents watch the child for a specific amount of time. The right of first refusal really is to address the situation where it's like a long stretch of time, like 6 hours or a day, where the parent isn't going to be with the child. They're arranging for someone else to essentially watch that child during that day. And in that scenario, basically giving the co-parent the first option or the right to say, "I'm gonna watch a child," instead of whoever it is you had lined up to watch the child. And that's also meant to reduce childcare costs. Again, especially where if work-related childcare is typically something that's split between the parents. So being able for the other parent to step in and say, I'm gonna I prefer to watch a child than have you leave them with a babysitter or some other childcare situation.
Right. Exactly. And I personally don't love right of first refusal language. A lot of judges don't like it because it leads to more situations where the parents just have to deal with one another and it can become problematic. So if you are going to have right of first refusal language, to Nicole's point, it should be a significant amount of time. It shouldn't just be a couple hours that the right of first refusal kicks in.
And I mean, we're going to talk about legal custody and decision making, but the other thing that, you know, why sometimes judges don't like the right of first refusal language is because it gives the other parent the right to sort of interfere with sort of the more day to day decision making that the parent who's responsible gets to make. And that includes, using childcare for their time as necessary, or setting up play dates or whatever it is with your child. Again, for your child, you don't want the co-parent being able to sort of impose themselves on the parent's time. And so that's where, again, right of first refusal can get really messy, where all of a sudden one parent wants to know exactly where the other parent is with the child at all times on their days. And then if they feel like the child isn't with the parent enough, they want to sort of step in and say, well, I should get that time. That should be my day. And it leads to more conflict and more disputes. And what we try to accomplish with parenting plans really is to set up a schedule and a plan to reduce conflict and reduce disputes as much as possible.
Right. Now, the parenting plan, you also may want to include language that deals with out of state or out of country travel. So, out of state is less important, but sometimes you'll see language that says, if either parent is traveling out of state with the child overnight, then they will give the other parent a rough itinerary of what's going on, including where they're staying. But it is more important for for travel out of the country because you want to make sure you put in a provision that says that the parents will cooperate in, getting the child a passport and making sure the parent who is traveling outside of the country has the passport that they need for travel. And again, you probably want to put in language that says if, either parent is traveling outside of the country with the child, they will give an itinerary to the other parent. Sometimes parents have concerns about the other parent taking the child to like a dangerous place. So what you'll sometimes see is that the parents are restricted from taking the children to countries that have like a homeland security warning level of a certain threshold. I forget off the top of my head what the numbers are. I want to say it's like level 1 through 5, something like that. And the most safe countries have a certain number. So you may put in that, the parent can take the child to countries that have a warning level of 4 or 5. And then if it's a different number where the country is potentially unsafe, then they can't take the child to those countries. Sometimes you'll see that language. It's pretty uncommon. Usually they just, can use their discretion in traveling outside of the country.
I mean, usually you see language that says the other parent has to agree for the child to be taken out of the country. Um, you know, that's pretty basic because, again, once you're out of the country and something happens, that other parent's ability to get involved and do something about the child is very much hampered.
I don't think that's necessarily, I don't think the norm is for the parent to have to agree to the child to leave the country. I mean, if parents like frequently travel outside of the country, then there's not going to be language that the other parent has to agree. I think what I like to put, I like to get ahead of this and know, like, is the other parent going to give you trouble on leaving the country? And I don't like to put in language that says they have to agree. I like to have language that enables them to leave the country. And then you kind of know if you have an issue, and then you can deal with it by saying if it's a certain threat level country, then you can't go to that country. I don't know.
Well, yeah, I think the reality is parents, what we're trying to avoid here is a situation where one parent is hindering the ability of the other parent to take the child on a trip because they're jealous that they're able to take the child on this like really cool trip and they feel like they're unable to do it. So they want to take away the other parent's ability to do it. And so you want to dissuade that type of behavior, right?
Yeah.
You don't want you don't want the children to have to pay the cost of parents kind of still feuding and having this sort of bad blood between them. But on the flip side, I think with out of the country travel, you definitely have a heightened level of certainly notice where they need to be provided like more than 30 days notice of any plans to travel outside of the country with the child. And then that way, if there really is a concern, valid concern that one parent has, but for the child traveling out of the country and the other parent isn't hearing it, that parent can go and file something, right, and try and get the court to intervene. But when it comes to in-state or in-country travel, so like a state like Connecticut, we're right next to New York, right next to Massachusetts, Rhode Island. you basically don't even necessarily need notice in those situations. Like, if I want to just hop on the train, take the kid into the city and come back, having to like give the other parent notice of that, again, sometimes feels like the other parent, it's like monitoring their parenting time with the child, which again, we're trying to avoid that. We're trying to not have one parent be in control of the other parent's uh, schedule and parenting time with with the child. But like you said, Matt, if the plan is to kind of be out of state overnight with the child, some notice again to the parents so that they understand where the child is. If something were to happen, they know where to locate the kid. And that way they're not concerned. They heard something happen, they know that the child isn't there, or and they know where the child is ultimately.
Right.
Uh,
So those are all the sort of physical custody provisions of a parenting plan, or at least those are the main ones. And then the parenting plan will also deal with legal custody. So the vast majority of cases are joint legal custody. So it'll just say the parents will share joint legal custody, or sometimes they will say that one parent has final decision making. So it's joint legal custody, final decision making if the parents are unable to reach an agreement. And that is more for the situation of, two reasonably involved and responsible parents, but they just really struggle to reach agreements on certain things. And you don't want to punish the kids by just having no agreement made and then things get delayed. So you got to give final decision making to one of the parents. Or you'll see sole legal custody in some situations. Again, that's more rare. It's not like the most rare thing in the world, but it's much less common than joint legal or joint legal final decision making to one parent. And that's really just where the non-sole legal custody parent is just not super involved or just not capable of making good decisions that are in the best interest of the child. And in that scenario, you will usually see the sort of more responsible parent, for lack of a better word, having sole legal custody. So that will be laid out in the parenting plan.
right. Where one parent is granted sole legal custody, the other parent in that scenario, the judge is basically convinced at that point that that parent shouldn't have a say in these sort of major life decisions of the child, for because that parent's judgment is not sound, or it would lead to a scenario where either the child is not safe, or it's just really not in the best interest for that other parent to have a say in these decisions. Now, even in a scenario where there is sole legal custody to one parent, that other parent still gets access to the child's educational records, medical records, so they could still find out what's going on with the child and be apprised of what's going on in the kid's life. But they don't get to make the decisions or intervene or interfere with the sole legal parent's right to make those decisions.
Correct. And there will often be sort of like boilerplate language with joint legal custody that says the two parents will do their best to reach an agreement about all things related to the health, education, religious upbringing of the child, and they'll try to work together. That's sort of like boilerplate language that is in a lot of agreements. A
But as
parenting
far
plan.
as, I'll just say, with joint legal custody versus joint legal with final decision making, we we don't see the final decision making used a ton, right? I think judges really do try to give both parents the same say in their child's lives, and again, on these big decisions like religion, medical, education, extracurriculars, all these bigger decisions, the court wants both parents to have a say and be involved, be consulted, and ultimately come to an agreement. And so where if they feel that the parents are unable to make an agreement, a lot of times they also prefer to see in agreements some mechanism for resolving disputes. So whether that's bringing it to some third party that the both parents agree they're going to use this third party to try and mediate this dispute, or have them kind of be the tiebreaker. That could be someone that both parties know and get along with and respect, right? So typically, sometimes it's a family member, but oftentimes it might just be like a friend that both people have, or it can be a co-parenting counselor or someone, again, a third party who isn't going to be biased in that scenario, and really kind of hear both sides and try and help them come to a decision. But if they're unable to resolve it through that mechanism, then they have to go back to court, file a motion, and seek the court's assistance in resolving the dispute. And
Right.
typically what that means is the court's going to decide who gets to make that decision from the two parents.
Right, because you really are not legally allowed to just sort of delegate a decision to a third party. You can't what you'll often see in parenting plans is something like if the parties are unable to reach an agreement as to where the child is going to go to school, they will work with a co-parenting counselor who will make a final decision essentially. And that's really not supposed to be approved by a judge because it's delegating the court's authority to a third party, which is not legal. There's been like appellate and Supreme Court cases that say you can't do that. With that said, like sometimes judges will still approve that language and it will be in there because from a practical standpoint, it can just be a lot easier to delegate that authority to a third party who can just make a decision if the parents are unable to make a decision. So
But again,
you're
if
not
that was
supposed
done and one parent is not approving of that, it could always be, again, if it's by agreement and the court approves it, then that's part of their agreement. The court will deal with it if it's ever brought up in a motion again. But
right.
if a court just ordered that as part of a decision on a custody case or a divorce case, that could be appealed.
But it's also not supposed to be in agreements, but sometimes judges just like let it go because it makes life easier to have a third party make decisions when
You also see a lot of provisions about mediation, right? So basically saying that the parties will need to attend one or two sessions in good faith, one or two mediation sessions to try and resolve this dispute before either party has the right to come back and file a motion with the court. And again, that really is trying to keep things out of the court, off the court's docket, and allowing the parents, empowering the parents to really resolve these disputes amongst themselves outside of court.
right. Because I think a lot of times people think like, oh, we'll never reach an agreement on this. Let me just file a motion. And then are surprised to learn that once they get into mediation, they actually do reach an agreement. And it's a lot easier than going to court and less stressful and cost less money, et cetera. So I would encourage you to put a provision in that says if there are any disputes that would lead to either parent filing a motion to modify the parenting plan, then they will first go to mediation to try to resolve it by agreement. And that, I guess that should also be said, is that anything that is in a parenting plan can always be modified if there is a substantial change in circumstance. So that is the standard where if things change, you can file a motion to try to get a modification to the parenting plan. And then the court may or may not grant that modification if they feel that doing so is in the best interest of the child after there has been a substantial change in circumstance. A parenting plan may also have the communication method between parents. So if parents really get along very poorly, then it may say that communication shall only be via email, for example. What is more common for parents who don't get along as a parenting plan will say they have to communicate exclusively through a program called Our Family Wizard or App Close. Those are two third-party softwares that are specifically designed for communication between separated individuals, ex-husbands and wives, or, just people who are no longer together. And it's just a platform that makes it easier to communicate. There's calendaring on there where you can put events, etc. So often you will see language that says they are to communicate exclusively through those programs. Also, that they are not to communicate through their children. You don't want to be putting your kids in the middle of a back and forth dispute between you and your spouse. Courts do not like that because it is not good for kids to be put in the middle of things.
A good thing about Our Family Wizard or App Close in situations where parties have a history of just conflict and being unable to communicate well is that if you're ordered to just use that platform to communicate with each other, each parent's going to be a lot more thoughtful about what they put into that platform, because anything in that platform could then be discoverable for a future motion to the court. So the court can, or if you file a motion with the court, you're going to either get a guardian ad litem involved or a family relations officer involved, and they'll be able to go back through the Our Family Wizard or the AppClose program and see what communications have been going back and forth. And again, it's getting people to behave better in the way that they communicate with each other when they're on these platforms, and also being able to, whether that's because you need to be able to communicate about your kid, but you don't want an individual who's just creating a lot of conflict and problems to be able to constantly contact the other parent and interfere in their lives. So it kind of, if you're only communicating on this platform, you sort of have the freedom to block them on other platforms, so that you can carry on without having this conflict constantly um, it presenting itself in your life every day.
Right. Now, back to the physical custody side of things. I mean, it's not really, but it's more related to physical custody than legal custody. You also may want to put in a provision for phone access, phone or FaceTime access to the children for the parent who is not with the children. So sometimes you'll see language that says the parent who is not with the children on any given night shall have like a good night FaceTime call with the kids, for example. That can be good to sort of facilitate and encourage the connection between the parent and the child. Sometimes if there's like really just like not a good relationship between the parents, then those sort of dinner calls can become problematic of, they can't necessarily be at the exact same time every night. So it only really works well when the parents have a good co-parenting relationship. But sometimes it is important to put that telephone access provision into a divorce agreement or
I mean,
custody agreement.
those provisions sometimes can create a lot of issues where if the child is having a hard time with a parent that they're supposed to be getting on the phone with or getting on a Zoom with, and that the parent on the other side is feeling that, this child is not actually talking to them, or they're not really utilizing the call or the Zoom or FaceTime, and then they start, they're blaming the other parent, and then they use that as an excuse to file a motion to say for of contempt, saying that this parent isn't giving me the phone call or the Zoom meeting, or the FaceTime. And so I think, again, it's rare to, or judges don't like to require there to be like phone calls or FaceTimes, but typically to include some language to say the parent who, the non-custodial parent at that time, the parent that isn't, the child is not with, if the child indicates that they want to call that parent, that the other parent will, assist with getting the child in contact with the other parent, right? To basically say that there is access to the other parent, um, if the child needs it, versus the other parent just wanting the access on the other parent's time so that they can sort of glean what is the child up to? What is the child doing with the other parent? Again, just not trying to avoid a scenario where you're allowing the other parent to essentially track or interfere with the parent's time with the child.
All right, Nicole, I think we have blabbed for long enough here about parenting plans and what should be in them. Do you feel that there's anything I missed, that we missed, that needs to be included?
Well, one thing I think that we often see is relocation is a big one. So again, typically with parenting plans, they are created with the understanding that we know where the parents are living, right? So they're living X miles away from each other, they're either in the same town or they're in different towns. But if one parent is going to move or relocate from their current residence, and it would impact the parenting plan. So whether it impacts transportation, it makes the commute for the child longer between the parents' residences or anything like that, the parents really need to agree. And so there's typically some type of language you put in place to say the parents are going to come to an agreement if one parent seeks to relocate and that relocation would result in a distance of more than X miles from the other parent, they have to agree before that relocation will occur. Otherwise, they have to file a motion with the court. And that's also part of one of our statutes, which is that if your move would interfere, impact the current parenting plan, then you need to seek permission from the court. If you can't, again, do it by agreement with your
Right.
co-parent.
Right. You need to seek permission to the court if you want to keep the current parenting plan in place. If you're going to give up parenting time, then you don't need the court's permission to move. It's really you're asking the court's permission to continue to exercise your parenting time under your new living situation.
Although if you did move and not with the intention of keeping your parenting time, you basically are moving and saying that the other parent, like they're taking themselves out of the equation, the other parent has to fully be responsible for the child. Well, there will be other repercussions to that, and that may, require additional support, more responsibility for whether it's childcare or a host of other things, because by doing that, you are really impacting the other parent who now has to take on the parenting time that you're no longer going to be responsible for.
Exactly. All right. Well, that is going to do it for this week's episode of the Irretrievable Breakdown podcast, where we discuss all things divorce. Again, those are sort of the basics on what you should be including in your parenting plan here in Connecticut. And as usual, if you have any additional questions, you can contact our office. And if you are looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well. Thanks for watching, and we will see you next week.